Hello, everybody. My name is Peter, and I'm going to be your host for this webinar this morning with our guests, GemServe and UK Tech. Now, there's a bit of a tradition with events like this. Whilst we wait for people to join, and it always takes 2 or 3 minutes, I'm afraid I'm going to put you through having to listen to some of my very bad dad jokes. Little difficult to find jokes about data flows, but let me see what I can do in talking about data science. So for those of us that have worked with data as architects or analysts, there is one thing I think that always holds true, is that data science is 80% about preparing the data. But I would like to say that the other 20% is about complaining about preparing the data. And that's certainly been the case as we get more and more data that enters our organizations now. Now, as a data scientist, and I've been one for over 20 years, I can tell you that data science and data is a little bit like people. If you interrogate it hard enough, it will tell you whatever it is that you would like to be able to hear. And if I had £1 for every email that I got about data protection, well, I would have to say it's private about how much I would earn from that. But it is an important subject. I know that when we were organizing this webinar for today, we had a huge amount of interest from people who are really thinking hard about data flows, particularly with so much change. We're going to come to that in a minute. But whilst people continue to log on, and I think we've got over 30 of you with us now, second parts of jokes. So what's the difference between Facebook and Jean-Luc Picard from Star Trek? Well, Captain Picard would never sell data. It's okay, you don't have to laugh. It would be rather surprising even if you did. And because this is a one-way broadcast, I can't even tell if you're grimacing or groaning. Now, a friend of mine recently accidentally deleted all my company data, and he told me that I just needed to calm down. So I did. I had a nice cup of tea, and then I hid his body under the patio. One of the things that I have been doing over the last few years is working a lot with artificial intelligence, particularly in the field of customer service and customer experience. And one thing I can definitely say about artificial intelligence is that it is no match for natural stupidity. It doesn't matter really what we do and how smart we make the systems work. There's always somebody can find a way of breaking it. Now, I've been really worried about compromising my personal data and privacy and what's going on. So Google, how do I protect my privacy? They don't get any better, I'm afraid, but we will start in a moment too. So I was visiting my hometown recently, and I drove past the data recovery center that I used to work at. It really brought back a lot of memories. And then my final parting shot, and then we can get on to the good stuff. There are two kinds of data scientists. Firstly, those who can extrapolate from incomplete data. And with that, I'd like to say welcome. My name is Peter Dorrington, and I'm going to be your host for this webinar this morning. And I'd like to welcome you all to the webinar with GemServe. So before we begin, let me just go through a little bit of housekeeping. As you can see, you do not need to worry about video or being on mute. This is a webinar rather than an interaction. So relax. I'm going to ask you to take part in a moment, but there is no arm twisting going on, and we don't have to worry about people walking behind you. There is, however, a chat function. If you haven't found it, it's on the right-hand side of the screen. And if you open it up, you can go into chat, and then I would actually ask you to use that. So put in questions, observations, or insights that you want to share, particularly questions. I'd like to come back to those as we go through this morning's session. So get your questions in. As I say, I'm not going to pick on anybody. I'm going to identify individuals. It won't appear in a video or recording or anything like that. So I did say that this webinar is being recorded, and it will be made available to you after the webinar. So it'll take a little while to sort that out, but I'll come back to you about how you can access that in a moment. So what are we going to do today? Well, in a moment, I'm going to hand over to our guest speakers, Samuel and Neil, who will introduce themselves, and then we'll talk about where are we today? And how did we get here? And what are the kinds of challenges or opportunities that we're seeing? And then we'll go into an interactive question and answer session. So this is where I would ask you, please put those questions into chat. I will be able to ask them on your behalf. And then 10 minutes before noon, there'll be a short summary. I'll finish off with a couple of final thoughts and including a call to action. And then I promise I will get you away on time. We will finish promptly at noon. And so on to the good stuff. So firstly, what I would like to do is ask our two guests to introduce themselves, and then we'll start to set the scene. So firstly, what I'm going to do is I'm going to ask Samuel. Samuel, if you wouldn't mind, would you introduce yourself, please?
Sure. So thank you, Hélène, for hosting this webinar. So I'm Samuel Plantier. I'm a principal consultant at GEMSOV. I specialize in data protection. As you can hear from my accent, I'm French. I qualified as a lawyer in France and I practiced for 2 years. And initially, I'm specializing basically in information technology and intellectual property law with a strong focus on data protection, and especially the areas where I'm really focusing on at the moment obviously is international data transfers and also digital advertising and e-privacy.
Wonderful. Thank you, Samuel. And next, I would like to ask our second guest and expert, Neil. Neil, would you mind introducing yourself?
Hi, everyone, and thanks very much, Hélène, for hosting the webinar. So my name is Neil Ross. I'm Head of Policy at Tech UK. So if you don't know Tech UK, we are the UK's largest trade association for the technology sector. We're a bit like, you might describe it as sort of the CBI for tech. We have about 850 members in our membership, representing about 750,000 workers in the technology sector across the UK. That's about 1 in 2 of every tech sector workers in the country. At Tech UK, I'm the head of policy, so responsible for our principal interactions with government and officials, parliamentarians, and some international organisations. During the Brexit negotiations, I was the lead point of contact for Tech UK, so dealt with all of our engagements with both the Commission and the UK government during the negotiations, and of course the data adequacy process.
Thank you very much, Neil. So what I'd like to quickly do is just recap our agenda for today. So we're almost through the welcome and the introductions and the housekeeping. In a second, I'm going to ask this question. Where are we today with international data flows? Where I really want to hear from both Samuel and Neil some of their thoughts. By the way, please do ask questions. That way, if you have something you would like to understand a little bit further, these are the people to ask. As I say, they're both experts in this field. And then at 10 to, quick summary, and then a close at 12 o'clock. So that's enough of the slides. You'll be pleased to hear that there is no slideware after this. This is a genuine conversation. So what I would like to do is open the question up really on where are we today? How did we get here? So 2020 has been an extraordinary year, as has the start to 2021. We've obviously had coronavirus. We've had Brexit. We've got a new US administration in place. We've had cases of data breaches and privacy and a huge discussion about where are we going. So let me first come to you, Samuel. Now, obviously, you're interacting with a lot of organizations in this field. What have you seen has been going on over this last year? And what are the things that really stood out to you?
It's a very interesting question because you have so many things which have happened in 2020 that it's difficult to do a single summary. But really, with obviously you have Brexit, which is affecting a lot of UK-based organizations and also European-based organizations, which are doing business with the UK for 40 years now. So you have this question of data flows between the UK and the EU, which is still very pregnant, as in like last week we had a draft adequacy decision, so it's extremely acute at the moment. We have the Schrems case, which disrupted an important part of the global data flow system, really, and putting in question the whole adequacy, the whole EU adequacy system. It's not just the US. It's also affecting the potential UK adequacy decision. It's affecting the general adequacy system between the EU and other countries like Canada, New Zealand, Israel, etc. So the very exciting times. You obviously have COVID-19, which moved a lot of organizations to embrace remote working with all the risks that's come with that. Your staff, your working force working remotely from everywhere in the world, with the security challenges that come with that. We are in the last weeks, for instance, we've seen a lot of in the news. We've seen a lot of news around ransomwares, which are starting to affect kind of organization. This is a huge risk for organizations moving online now. I would say that the main cybersecurity / privacy risk is residing with that in the next month, because organizations are targeted with what is what is the most important for them, which is like being able to access your data easily. It's not just only personal data, but it's affecting indirectly personal data. So a lot of interesting questions at the moment, and where we are at in terms of data flows. To do a brief summary, a brief overview of where we are at the moment. So the UK has left Europe, the EU. So we are. At the moment, we are in a transition period for 4 to 6 months, where basically the UK is treated as part of the EA for data protection purposes. It's a bit technical, but for now, nothing changes. And this transition period is used to basically grant an adequacy decision to the UK. So this has not happened yet, but there is a draft decision which has been published last week from the EU Commission, which should be adopted. We can have reasonable expectations that it's going to be adopted, but again, it's European institutions. We can always expect a surprise from a member state saying that no, I don't want it, or European Parliament or the EDPB giving out strong concerns about this draft adequacy decision. But we can expect that reasonably expect that he will be adopted. But one thing is that this adequacy decision, for instance, is only the draft is only for 4 years. The adequacy decision will be only for 4 years. So the data flows will be safeguarded only for 4 years. And this is because the UK has been, in particular, saying in the past month that they would like to amend the data protection framework. So the EU doesn't want to be committed to an adequacy decision if the UK is going to change the framework, and this is fairly new in the adequacy system in Europe. The last adequacy decision in Japan didn't take this approach, for instance, except the regular review of Japan adequacy. You don't have this expiration date where you have like to renew an adequacy decision. So this is fairly new with the UK. And obviously, another point which isn't really addressed with this draft adequacy decision is the impact of Schrems case. The UK the adequacy decision doesn't really focus on that, because we can see that probably the European Commission is perhaps a bit embarrassed by this judgment, which we don't really know what to do with it, because it's been affecting a lot the US because of the mass surveillance intelligence services, etc. But if you look a bit more closer to it, you can see that the findings of the European Court of Justice are also applicable to a lot of countries which are part of the adequacy system. Interestingly, most of the countries who have been granted an adequacy decision in the past are also members of the Five Eyes. So you have Canada, you have New Zealand, and the same questions that were relevant for the US are actually fairly relevant for those countries. So with the UK, which are also members of the Five Eyes. With the UK, you can even go a bit further, saying that actually, physically, most of the internet traffic in Europe is going through the UK because of the cables are going there. So this question is unaddressed for now by the draft adequacy decision, and you can see that it's really an issue, a potential issue, and a potential that it will be potentially open to challenges by activists like Max Schrems, but also other organizations which are going to say, hang on, why the UK is granted an adequacy decision, where you actually have the Schrems case judgment, which saying that intelligence services should be taken into account. And this is really true, but still we don't know. We still want the UK to be part of the global data flow system. The UK can't be avoided. A lot of companies are transferring data to the UK. So how does it work? So all those questions that are interesting. The new draft standard contractual clauses are not really are trying to address this question without really resolving it. So this is really where we are, and perhaps I've talked too much. I'm going to leave a bit the floor to Neil on these questions. But
no, thank you, Samuel. I can see we've got a question. I'm going to come back to that in a moment, but before I do, what I'd like to firstly do is, Neil, you're in a different position. Not only are you working with a body representing so many IT and technical professionals, but clearly plugged into what's going on in government as well and the international scene. What's the kind of things you've been hearing over the last year? You know, where do you think we are right now, and what are perhaps some of the challenges and opportunities?
So I think when you sort of think about 2020, first of all, I think 2021 is effectively defined by 2020. We are now sort of living with the consequences of 2020 coming on stream. And 2020, particularly for a lot of the businesses I've spoken to and government we've engaged with, was a year where change happened and happened very, very quickly. And it wasn't necessarily unexpected change. You know, we spent a lot of time over the last few years talking about how more small businesses are going to go online, how businesses need to understand and map their data more because the international data system is getting confusing, that businesses want to use digital more to boost productivity and find new ways of working, that more people are going to work from home. And all of these things have now happened, but at a significantly faster pace than anyone would have expected. And when that happens, it's not only businesses struggling to keep up or trying to adapt themselves, but the rules around which these things are managed start to creak and break at the same time. And we've had a number of judgments and rulings and issues that Samuel has cantered through that demonstrates that. The UK leaving the European Union, Schrems II, changes in the way that people are now thinking about data and privacy now that we live in an even more digital world. So 2021 is us catching up with that change and learning to adapt to it and thinking through what the implications might be. Obviously, that's laden with a huge number of challenges. I think the principal one we think about data is how we get the balance right between trust and innovation. So lots of our companies use data, use people's personal information, use non-personal data to construct digital services, whether that's for foods delivery, it's a search engine, it's online shopping, it's a financial service, it's any kind of service you think of. And these are brilliant. They result in lower costs for consumers, a wider range of choices, and more efficiency. But in order to access those services, people need to trust that their data is being used effectively, that there are adequate protections in place. So sometimes when we've talked about data policy, there's a trade-off, people talk about a trade-off between companies and privacy, and that's just not a valid. It's not true. The argument, you need both trust and innovation to make these things work. If people don't trust that their data is not being handled correctly, they won't use the product. So as we go forward, we need to balance that challenge of getting the right trusted framework, but enabling innovation so that we can have the best possible digital services and a good, strong tech economy for the UK as we go forward.
Oh, thank you, Neil. That's I'm going to come back to that in just a second, actually, because I think there are a couple of really good points that you put into that. Before I do, there was just one quick question that's already come in. So it's about confirming understanding of what I think, Samuel, you were saying. The UK will make their own adequacy decisions for transfers from the UK to third parties outside of the European Economic Area. Is that what you were actually saying? And am I right in thinking that what we're saying is that's for the transitionary period for another 4 years or so?
So it's a different question, but So for the 4 years to come, what I was saying is that the UK will be considered as adequate from a EU perspective. So data will be able to flow freely from the EU to the UK, but only for 4 years. It will have to be reconfirmed, I would say. On the other side, from the UK perspective, so that's an interesting question because it's a bit technical. But for the 6-month period we are in at the moment, the UK isn't actually able to do that, to have an autonomous data protection policy. The ICO isn't able to issue certification schemes. The ICO isn't able to issue BCRs or to deem third-party countries adequate. However, that's absolutely temporary. After the 6-month period, absolutely, the UK will be completely autonomous about that, and this is going to raise a few interesting questions. So, at the moment, the adequate countries that have been deemed adequate by the EU are also adequate from a UK perspective. It's absolutely replicated onto that. The Schrems case is part of UK law because the UK was subject to the rule of the Court of Justice at the time of the Schrems case. So the findings of the Schrems case are also applicable in the UK for now. But it will be interesting to see if it diverges in a few years. What about, let's say, the UK is saying again, oh well, actually the privacy shield, I'm happy with that, so I'm going to deem the privacy shield adequate, and the data will be able to flow freely from the UK to the US, but the EU still not having make a replacement. That could very well happen, and so that's a few points that we really need to monitor in the next years. And for 2021 especially, what we know is that there is a lot of demand, a lot of pressure in the US to have a federal privacy law, and it will very likely happen in 2021 with the new administration and with the general fact that all states are independently adopting privacy laws. It's making business very difficult now in the US. As someone who is dealing with companies who have economic interest in the US, I can say that it's becoming fairly hard to keep track of everything that's happening. So a federal privacy law will be absolutely welcome. However, I think that we shouldn't expect too much from the Biden administration in terms of intelligence services and the findings of the Schrems case. Probably you will see a few changes with more safeguards around the balance of power, how the administration can request access to data, etc. You will perhaps see a few cosmetic changes, but I'm not sure there will be enough, or you will see a complete change of paradigm that will make the findings of the Schrems case obsolete. And this is also something we need to keep track of. It's the findings of the Schrems case that have prevented the data to flow to the US. They will still probably be up in the air for the few years to come.
Thank you very much, Samuel. Now I'm going to come back just briefly to a point that Neil raised. Well, firstly, no doubt, I think in anybody's mind, 2020 was a year of change. I tend to look at it as a catalyst. Some things that were happening slowly suddenly accelerated, but a lot of businesses actually had to pivot to becoming digital very quickly. And look at what's happened with the retail sector and perhaps entertainment as well. Now that has caused great opportunities, but I think also some real challenges. When we entered into lockdown in the UK and a lot of people started to work from home, I think the first challenge people came across was technical. How do we get all the technology to work? And then they looked at procedural, and more latterly, perhaps they've been thinking about people. But some of the things that has thrown out, Neil, to your point, what does that mean for privacy when people are accessing data at home in an environment that may not be completely secure? But actually, what I was more interested in is in that dash to digital, it has created some new opportunities. There is a lot more data available, and a lot of that is being hosted in things like the cloud on big platforms, because that was the way that you could scale very quickly. So, Neil, perhaps you could just say a little bit more about what you're hearing, about what people are talking about, the outcomes of this dash to digital, and what that might mean for the immediate future, and certainly for the next couple of years, perhaps.
Yes, so I think that's exactly right. And seeing it as a catalyst in some areas, although it's important to say that in other areas, things have been completely frozen. Some sectors do not have any money to invest and potentially will come out having been supported by the government schemes and having to pivot or catch up even in sort of early 2020 or early to mid 2021. And there's obviously the colossal human cost as well, which has really kind of held things back. So it's important, I think, as well to when you look across the whole economy, that it's not quite sort of as dynamic or as sort of as interesting, or not interesting, sorry, certainly not as dynamic and as much change as there was before. Some people are still effectively frozen where they were in 2020. So there's probably likely to be big unevenness across the economy. Certainly on the working from home thing, working from home, you're now almost an extension of your office. And it means that things like cybersecurity skills and the cybersecurity practices of different companies will come now more onto the spotlight, not only because people will want to feel comfortable that they're working in a secure environment, but because it will become simply more business critical to ensure that you have good cybersecurity software and you're able to keep up with the latest threats. Because a cyber attack, which probably wasn't a top flight risk for most companies, will now jump up to near the top of the queue and can be hugely damaging if one is successful. Other things which we still need to kind of bear in mind is just what this kind of shift to working from home will do for the economy overall, or where data wants to be gathered from. If you end up in a situation where people move from living principally in cities or living in kind of the center of cities to more commuting and spending a bit more time in certain clusters and then commuting into the center of the city, that has huge economic ramifications, but also big public service ramifications as well, about where services are delivered, how transport networks work. And all of that will be revealed in the data that's gathered and produced as we kind of transition. So ensuring that we can access and analyze and use that to update our public services as well as business needs will be hugely important as we go forward.
Thank you, Neil. Samuel, would you like to add anything to that? You know, the dangers and the opportunities of the dash to digital.
Yeah, no, absolutely. What I'm seeing the most. So you had this period from March 2020 where the top priority was to go digital, to be able to have your workforce working remotely, etc. So I would say that this is mostly addressed by organizations, but now you are seeing the other issues, which are how do you keep your data secure, and and the question of resilience as well, which is not yet completely acute, but you've seen at some point in a few months ago, there was this blackout from Google for a few hours, and it was really the panic for companies which were relying on G Suite, for instance. A few of my clients are relying on the Google Suite and Google Drive, etc. And basically, you have all your working environment, Office Suite, that doesn't work anymore for a few hours. So the resilience of those services is extremely important, but on the other side, you also have the issue of cybersecurity, as Neil was mentioning. Like, you have all your staff working from home. So how do you ensure that your data is kept secured and that transfers between your employees and your servers are kept secured? Usually, most organizations now have VPN. They have implemented the right, the correct approaches to that. But it makes having your workforce working all remotely is also making you an easier target for ransomwares. And we've seen that it's starting in the news, and I think it's starting to come up in the news very accurately, very frequently now in the past few weeks. And I think this is going to be probably in the highlights for 2021. Ransomware are going to be a real issue for companies, and how you keep your data secure. The thing is that you can protect yourself to some extent, but not completely. The zero risk doesn't exist. So how do you find a good balance between good enough security and not completely impeding your business? So these are very, very, very acute questions at the moment that are mainly unresolved. I mean, you can have companies now are realizing that you need to invest in cybersecurity, probably more than last year, but it's still up in the air. How do you ensure that Microsoft, Google are resilient services? It's still up in the air. How do you, as a company, how do you prevent yourself from Google going in blackout for a few hours? Do you really have a solution to that?
Yeah, really good question. I think one of the things that struck me about this, as we were talking about security and privacy and working from home, is I've seen a number of organizations have actually been extending a policy of bring your own device. And what we're seeing is hybrids. So people who are using one device for their personal use and for their business use, particularly as they see that, well, the cloud is secure and I don't need to worry about, logging in and, but they aren't thinking about what happens when you use one device for that dual purpose. And I don't think that that's actually really reached the consciousness of people in perhaps the same way that we've seen those concerns about privacy with WhatsApp and Facebook. Not so much again in Europe, because we've perhaps not been so badly affected by that, but you can see how importantly consumers value their privacy when they're leaving an application because they don't like an extension of their data being made available to, as they see it, a third party with whom they have no interest. I'm going to start the Q&A now. And in fact, we've had our first question. So have you any views on the Cloud Act regarding data flow? If the UK, for example, decides to sign it, I understand that the data would flow freely between the countries. So, obviously cloud has been an enormous enabler, both for storage and applications, and it does mean that there perhaps is more flexibility on the devices that we use. But what are your thoughts on this? And Samuel, I'll come back to you, and then I'll come back to Neil after you've had a chance to answer. So your thoughts about the Cloud Act regarding data flows?
So I wouldn't consider the Cloud Act as an instrument which allows free data flows between the UK and the US. The Cloud Act is in the US really the possibility for enforcement services, police forces, etc., to request access to data that is stored outside of the US to companies that are located in the US, for instance, Microsoft, and to request, I want the data that you are storing about this person, but it's actually stored in a server in Ireland, and I order you to give me access to this data. So that's the principle, the main rationale behind the Cloud Act. Whether the UK or not is part of it doesn't really matter, because, well, this is really a US-based instrument. But it did raise challenges from other countries' perspective, not only the EU, but obviously it's making US law extraterritorial. So it's a real concern. I don't think this is going to change with the Biden administration. We know from past experiences that US law tends to be extraterritorial, to reach outside of its borders in many areas. Data is one of them. Is probably not going to change. What we could see, however, is the UK and the US either entering into a free data flow agreement, like the Privacy Shield, for instance, or another sort of instrument, but also strengthening their already existent intelligence services cooperation. And from a EU perspective, this would be probably worrying, not particularly new. It was already the case when the UK was part of the EU. But one thing we can also see from the adequacy decision, the draft adequacy decision from the EU to the UK, is that one guarantee the EU is considering for the UK is that the UK is part of the Convention of Human Rights of the European Convention of Human Rights, which still includes some safeguards around intelligence and mass surveillance. Whether it will be efficient or not, we will see.
Thank you very much, Samuel. Neil, do you want to add anything to that?
No, I think Samuel's kind of gone through what are the sort of the legal nature of all. I think one thing just to consider in the round is that data protection policies generally have become more extraterritorial. The GDPR itself has extraterritorial implications.
Absolutely. Yeah.
And as we think about the future navigating of data flows and the arrangements that countries have with one another, companies will just have to be able to understand the different networks interconnections and what you'll need to do if you want to be able to transfer data to the US. It's not the case necessarily at the moment, but it's not unforeseeable in the future that the UK would have competing data flows arrangements with the EU and the US, and that means that you may have to separate out data sets in order to fulfill those transfers. Japan already has a similar agreement. They're members of the Comprehensive Pacific Trade and Partnership Pact. They have an EU adequacy decision, they have an EU trade agreement, and they also have a digital agreement with the United States. So there are huge possibilities for these kind of overlapping agreements. What we need is good, well-written and clear guidance and toolkits provided by regulators and by UK authorities to help companies navigate those different opportunities. And that's how you will be able to maximize the different business options available to you. But it's the role of government and therefore the role of industry to work with them to first of all help identify, what deals can you strike, what are the competing interests, and then how do we ensure that our regulators and our system provides the most support for companies so that we have a really good business environment and one that obviously protects privacy as well.
Great, thank you very much, Neil. There's been another question come in, which if we can answer it briefly, we will. Otherwise, perhaps this is one we'll circle back to after. So where can employees working from home go to find out more about how to be secure at home? As a lot of the technology wording is quite difficult for home workers to understand. I know, I've been there and I've been in the industry 40 years. So Cyber Essentials is a start, but still needs translating. So either of you, where can we go as home workers to find out more about how to say secure, how to protect ourselves and our organizations?
It's a very good question. I think, if I'm not mistaken, I think the ICO has published a guide on how to work remotely from in a secure way that is a bit more accessible than standards, information security standards. I think it would be a good start, probably, to have a look at that.
And Neil?
Absolutely. No, I think things like Cyber Essentials are hugely important. The ICO's Cyber Guide is very useful as well. It is about moving on to this next stage of trying to ensure that the guidance is understandable for common consumers, because it's going to account for so much of the economy going forward. And with cyber, often what the case is that off-the-shelf solutions work for quite a lot of customers. But once you get to a certain scale and size, you end up needing more bespoke solutions. And really, that's the point when effectively you will have to kind of combine, I think, the Cyber Essentials guides and the ICO guides, but companies will also have to have strong internal processes and training to help their staff understand what's required of them. Cyber is a bit like a whole host of other things where you're only as strong as your weakest link. So ensuring that that there's a good common understanding across the company is very important for the company, but we also need that in society, and that's the role of the regulators and government.
Great, thank you very much both. Perhaps what we can do is we can come back round to that in the post-event follow-up. We'll perhaps put that in there. So I'm going to ask a leading question, and I forgive about this, but clearly with Brexit, it wasn't all as smooth sailing as we thought. So there are lots of things that we're discovering as we work our way through the changes. So what do you both think is next for data flows between the EU and the UK? I know, Samuel, you've given quite a lot in there, but is there anything else lurking around that we haven't really thought about? How are we going to make sure this is as smooth a transition as possible, particularly after that grace period of 4 years?
Yeah, so it's interesting. I would say that with the draft adequacy decision, we can reasonably expect that the situation will stay the same for the next 4 years at least. What is lurking, really, I would say, is the UK strategy in terms of data and the what we've seen the government wish to become a data hub and to also to make more flexible the rules around privacy and data protection. And what I would say about that is well, obviously, it's encouraging innovation and business, and I'm sure Neil is adamant about that. What I would say is that from my perspective with my clients, I haven't seen a lot of appetite from organizations to implement a new data protection law. Businesses have spent 2 years already to implement the GDPR, painstakingly sometimes. It was a huge shift compared to the Data Protection Act 1998. So I'm not sure that a complete revamp of the data protection framework in the UK is welcome at this stage. But it can happen in the next few years, and it will have consequences not only for businesses in the UK, but also from a EU perspective with this draft adequacy decision. And this is really an area to monitor.
Thank you, Samuel. Neil, you were involved in the original discussions. Is there anything else you've seen that's been perhaps just around the corner?
Yeah, so I think that there are effectively two questions when it comes to any kind of post-Brexit discussion. There's one is this a question of the implementation? I.e., is it just really difficult to work out how to implement the new rules, and that's causing increased business costs? A good example of this is customs declarations at borders. Absolutely. And the use of online trading platforms, etc., to send goods around the EU. These are very high costs at the moment because, unfortunately, we had like 7 days to work out exactly what we needed to do. So companies had to adapt very quickly, and that means there's high initial costs. But I would be very confident that over time, the cost of sending goods and packages between the UK and the EU will drop to a very, very cheap, easy-to-use level once the system's bed in. The other one is, if it's not a question of implementation, is it a question of policy? And does that mean that the core trade agreement or any of the side agreements related to it need to change to make things better? If it's a question of policy, then I think you are sort of waiting for much longer term changes that, the fix will probably not come very quickly. And what that means, not just in necessarily data or other places, but across the economy, is that some of the trade and the business that was being done between the UK and EU is just no longer economic anymore. It doesn't work because the single market and the customs union underpin the business model. Those are gone, they aren't coming back, and therefore that business model will either have to adapt, or unfortunately the company may be forced to go out of business in the end, depending on the impacts. When it comes to data, we've almost got a sort of a halfway house. So the core trade agreement has something in it called a digital trade chapter. So the digital trade chapter is a kind of permanent feature of the trade agreement, or as permanent as the trade agreement itself is. Which sets sort of strong non-discrimination clauses, meaning that companies can't say, well, I'm not exchanging data with the UK because it's a UK company. You can't discriminate on a national basis. There's a positive obligation for data flows in various other areas. But personal data protection is carved out of trade agreements. It's not tends to be involved in them. And then we have this adequacy process, which is rolling on the side. So while you have both a positive adequacy decision over these next 4 years and the non-discrimination clauses in the trade agreement, you're pretty close to what the UK has as a member state in terms of being able to trade between the UK and the EU. Not 100% there because there are some exceptions, but pretty close. If the adequacy decision were to fall away at any point over the next 4 years, then you need to find your alternative legal basis in order to do those transfers. So data kind of almost falls in between those 2 points of is it implementation or policy. It is both. It is policy in terms of what's in the trade agreement, but implementation in terms of the ongoing discussion around personal data protection and data transfers.
Great, thank you. I'm sure that there's going to be a lot of unexpected opportunities and challenges as we go through this process, particularly as the UK is looking to form closer trading ties with a global economy. Now, we've mentioned Schrems before, and it was something I think was really interesting. I pricked up my ears to hear about it. I mean, we've talked about the UK and the EU, but what about UK, EU, and US? Is there anything else we need to be thinking about there? And do we need to be playing an active role in, I imagine it's not Biden's top priority, but how about influencing their strategy and their governance? Because I think that there is definitely a mindset difference that I've seen between perhaps the European mindset and perhaps the US. So I mean, what about the future for data transfers between the UK, EU, and the US? Anything we should be focusing on there?
It's an interesting question. As I said, I don't think with the Biden administration we'll see a huge changes in terms of the findings of the Schrems case. However, we can perhaps see something emerging, which is that perhaps from a European perspective, from a Euro perspective, sharing intelligence data with the US is perhaps still better than hosting the data in Russia or in China or in India. And perhaps there will be the very slow change of mindset in the years 2020s, I would say, that it's obviously, having the data stored in the US with big tech companies like Google, Facebook, etc. is not ideal, but is really trusting the data to large companies, large Chinese companies better. That's what we will see, and I think this is really a debate that is going to be pervasive in the EU. Obviously, what would be ideal is to have EU champions, but we're not there yet. So at the moment, the EU can't really become a complete island of data with just data stored in Europe. So we are relying on services that are global. That's the nature of the internet. So perhaps with enough both a bit of change from a EU perspective in the global geopolitical context, I would say, and also some guarantees brought by the Biden administration in terms of providing a few more safeguards in terms of intelligence services could help the EU and the UK to build a different data flows relationship with the US. And that would be, I think, the focus of organizations like Tech UK to build this strategy and this conversation with the government, like basically providing, businesses, we are doing data flows. We cannot stop. This is happening. So how do we make sure this is happening?
Yeah, thank you. Neil, what about you? You've talked about the difference between implementation and policy. Is there a way that we could or should be trying to influence policy with the US?
Yeah, so I think one of the great things about the new Biden administration is the kind of key message for them is that multilateralism is back, and that has to be one of the core ways in which to address this. What you really need in order to ensure that there is effective channels for data flows around the world is not only individual national data protection rules and organizations, but also avenues for data to flow based on common principles, methods for redress that are then accepted by the countries who are partner to it. So in this sort of space, a role we envisage for the UK is to kind of enter as a kind of new, essentially a kind of, not really, but you can almost describe it as a pair of fresh eyes, having left the EU, but always been a bit more inclined towards maybe a slightly more US approach to handling some of these things, but having a generally different view from the EU internally. Even when the UK was in the Council, the UK was in the EU Council, was often one of the kind of more liberal members or more innovation-focused members when it came to data protection discussions. So how do you then build that consensus? And it will require a bit of give and take from both sides. It will probably require the US moving a bit more towards having a federal data law, etc. But it will probably also require the EU moving towards not requiring other countries to simply follow its rules, but finding kind of shared principles that that work and set a common basis for everyone. And I think that's how you're much more likely to end up in a position where you will have a large, almost zone or group of countries who share data on a common basis. I think it's very unlikely you'll get global data flows in properly global schemes, but you can certainly move towards having more multilateral schemes that make that easier across large trade zones.
Great, thank you, Neil. It's interesting because I think that when we look at the large platform providers and the way that they're hosting data, there are a number of things going on. First of which, as we've seen, there's been a little bit of an upsurge of people wanting to take some control over that at a national level and perhaps beginning an international movement. But we do need them. We do need to be able to store data and access it and utilize it. Some people call data the new black gold. I don't think it is. I think it's more like clay. It doesn't really have much value until you do something with it, but it does have a risk. You know, the more data you collect, the more risk you take on board. We've had another question come in. Samuel, this might be perhaps for you to start with this. So the question is, we process data on behalf of a client for some EU data subjects on a small scale. are we required to have an EU representative even if UK get adequacy decision?
Yes, it's interesting, and there are several points actually in these questions. So the first point is when you are a UK-based business processing data in Europe on a regular basis, you need to appoint a representative, and this is irrespective of an adequacy decision. So that's the change with Brexit. Whether or not there is an adequacy decision, you will need to appoint a representative in the UK, in the EU. Sorry. In terms of I don't think so. It's an interesting question because I'm actually not sure how to answer on the small scales point. I don't think that changes something in terms of having to appoint a representative. The only limit to this principle to international transfers and appointing a representative under the GDPR is when the processing is occasional, when you are not processing personal data from EU citizens, EU residents on a regular basis. So I would say that even if it's on a small scale, but it's a regular part of your business, I will still tend to consider that he will trigger the requirement to appoint a representative. It doesn't have to be a full-fledged branch, but I would say that he would trigger this requirement. Yes.
Okay, thank you. Neil, I don't know if you want to add anything to that. I think Samuel's given a quite comprehensive answer to it, but.
No, I think Samuel's given a very comprehensive answer to that. There's not much more I can say on top of that.
Okay. This is, I guess it's not a question, but it's from one of the people on the chat. I often signpost staff to the NCSC website, Security at Home, since there is a section in there for individuals and families that is easier to digest. Thank you for sharing that. I'm going to go and check that out myself because
yeah, me too.
It's a bit of an arcane subject. Now, I guess this probably will be the last question. Very quickly then, what's the future for GDPR in the UK in light of the National Data Strategy? So, I had to go through all the GDPR stuff. It seems like it made up a big proportion of my life. What next for GDPR?
So I suppose I can maybe kick this off in terms of what we as an industry have been saying to the government in relation to the National Data Strategy. So I think, as you pointed out earlier, the GDPR was only implemented, 2 years ago. I remember having to do GDPR training. I think we all remember having to do it. There is no widespread call from the industry to get rid of the GDPR or to radically change the GDPR. I think there are important and legitimate questions about how the GDPR is implemented and how it's regulated, and the role of the Data Protection Authority in ensuring that companies comply with it. So, for example, one thing is that the GDPR has numerous legal bases, but often consent is prized above all other, and principal guidance relates to consent, whereas potentially expanding the guidance around the other forms of legal basis improve the way we can process data. There are also then, I think, further questions about how we make data more available, how we improve our infrastructure, how we improve data skills, all things which sit under the missions of the National Data Strategy. But certainly the call from the industry is not revolution, but it is evolve the system, make it work better for people, exploit the flexibilities that already exist in the law. And it's important to remember that the UK was one of the kind of leading countries in designing the GDPR during the negotiations in the EU. So this is as much the regulation that we helped build as it is an EU regulation. And therefore, as we think about the future of the UK GDPR, it's about adapting that regulation to better fit our own purposes. And it also provides a really strong basis for global transfers. It gives us a great place to start, but we can think about how we change it. That opens up dialogues and discussions with the EU, who will be thinking about doing the same thing. And it builds a good conversation to ensure that the UK and the EU have a consistent dialogue on these issues, which is just important for everybody in the long run.
Thank you, Neil. Yeah, I think we're all comfortable with the principles that sit behind GDPR. So I don't think the policy is a huge change that we're thinking of, but perhaps implementation. What about you, Samuel? Anything you would like to add to that?
Yes, sure. I don't think that in the next years we will see major changes to the UK data protection framework for two reasons. I don't think there is an appetite from businesses to implement a new data protection law. The other point is also now this draft adequacy decision, which is basically if what it says is that if the UK data protection framework changes too much in 4 years, then the UK won't be adequate anymore. So there are really two limitations in terms of how far the data protection framework can change in the UK, can be amended. But one thing we can perhaps expect, I think, which will be interesting, is that we'll probably start to see divergences between the interpretation of GDPR between the ICO and the rest of Europe. It was already the case, unfortunately, because you see a lot of data protection authorities in Europe taking different approaches to different matters. But you still have the European Data Protection Board, which is more or less efficiently aligning the different views of data protection authorities. The ICO won't be part of that anymore, and you can, in the next few years, perhaps you will start to see some divergences in the interpretation of GDPR in the UK and in Europe. So that will be some area to watch probably.
Thank you, Samuel. We're running short on time, so I know there are a couple more questions in the chat. I'm going to take one. What I will say is if you can get your question into chat now, we will make a record of it. We will circle back to you. If we can't answer it now, we will come back to you in the follow-up. So the next question, regarding appointment of a EU rep, what about if the processing of personal data is only business-to-business data, i.e. email addresses, contact details?
The answer for this one is actually pretty quick, although it can be it can go a bit more technical. But the GDPR doesn't make the distinction between B2B or B2C data. So if you are processing B2B data, it triggers the same requirements. That's the very short answer to that.
Great, thank you. We've got a couple of minutes left. So what I'm going to do is start to draw us to a close. So I want to firstly thank you both for those amazing insights. Actually, what I might do is I promised I'd get you away on time. I think what I will do is I'll do a quick summary, but if anybody wanted to hang on for one moment after 12 o'clock, we may have a chance to do that. But so what have I heard then? Well, clearly 2020 was a catalyst year. So much change was forced upon us, either compelled upon us or we volunteered to do it. We, not least of which, we went through Brexit. We didn't postpone any of that. We just plowed on ahead. Now that we're still working our way through that. We're still working our way through what's happening with digital businesses, what's happening with the way that we got those data. I saw in the first half of the year some things with people processing data, which was really quite worrying. They were using live customer data to test some of their platforms. That was certainly an issue. I've also been aware that there has been an uptick already in things like ransomware and some failures in the remote working environment. So we do need to make sure that we have those in place, that we do put those protections in there. I think, as Samuel and Neil both say, that if we look at the US administration, they've got a lot on their plate. A new president's come in, he's got a number of things he needs to deal with, but we are already seeing that there is international appetite to redress the issue about data storage, analysis, privacy and security. We've always had this conversation about the security services and what we can and cannot share, because we live in a world where the threats are global. So taking a nationalist stance is perhaps rather short-sighted and may leave us open to some things we hadn't thought about. So before I wrap up, I'm just going to come back to one very brief thing for both Samuel and Neil. So in just 30 seconds each, what are you looking forward to over the next year? What's exciting you? And I'm going to go to Neil first. So Neil, what are you looking forward to over the next year? What's exciting you?
To be honest, it's almost just having these kind of discussions over and over again. I think the way that you discussed at the start as opportunities and challenges, and how do you navigate that, and what are the debates that inform how you maximize the opportunities while minimizing the challenges in this space, are enormous, and they're so important not only for the next year, but actually really for the next 10 to 15 years in terms of getting the right balance between data protection and also the use of data for innovation. because we know the risks of failing to have good privacy standards, but we also know the benefits of having a really strong digital economy. We've been living with those for the last year. The fact that we, in many companies, have been able to quickly transition to working on the cloud, continuing to see our family and friends, even if not the way we wanted to. This situation and what we've experienced in the last year would have been so immeasurably worse if it happened even just 10 years ago. So ensuring that we continue on that trackway of innovation is so vital, and therefore I'm just keen to kind of having these discussions as we go forward.
Thank you, Neil. Samuel, your final thoughts. What's exciting you about the future? What's coming up over the next year or so?
Yes, there are a lot of work in progress, I would say, and interesting stuff to follow: the privacy regulation, the standard contractual clauses, the UK adequacy. But I think the main development that is exciting me the most is probably a US federal privacy law. And the reason is that the way the strength of this privacy law, of this federal privacy law, is probably going to define data protection for the years to come, and how the UK, the US, and the EU are going to work together in terms of data flows. I think this is probably going to be a pretty large foundation for data privacy in the years to come, and I'm really interested to see the developments in this area.
Thank you, Samuel. So, well, firstly, that's been an incredibly informative webinar. I've learned so much as well. So I follow up then. So what will happen? I'm going to come to the question, by the way, after we reach the formal close. GemServe will contact you with a post-event email. So expect that. So look out for it. It will include instructions on how to access the recording of this webinar, and we'll try to answer any remaining questions we couldn't get to. So we'll offer you the opportunity to engage with us, to actually look at those questions. I've got one more left in the chat I'm going to come to in a moment. Secondly, feel free to contact either GemServe to discuss your data flow challenges or opportunities, or to Neil at Tech UK about how you can participate in the initiatives that they're working with. So about membership, or about how you can find access to great learning and opportunity with that. So all that really remains for me to do is to firstly thank our experts. So Samuel, Neil, thank you so much. As I said, really informative and easy to understand. So thank you, I appreciate that. I want to thank GemServe, who made this webinar possible, as well as the Executive Leaders Network, who've organized this event and handled all of the logistics and the invitations. But of course, what I'd like to do is thank you, our audience, for taking part. Thank you for the questions in the chat. That's really illustrated a couple of points I think we will need to circle back to on another occasion, which I will do in a moment. But before I do, all I really need to do then is say thank you so much and goodbye, and we'll look forward to talking to you again soon.
Thank you very much.
And so I did promise I would go slightly over with this remaining question. So we have one question in chat we didn't have a chance to get to. So following on from the question regarding appointment of an EU rep, if an EU resident submits a comment on a planning application or buys something from our online shop, then this is an occasional transfer. Or are they in effect consenting to supplying their data for specific purposes? Therefore, it's not a data transfer in the same sense that's being discussed here. So quite a long question there. I think what we're saying is, you know, if you have an EU resident who is dealing with the UK, either through something in the data or in private, is that really a transfer of data and consent, or is it classed as something else? I'm going to come to you first for this, Samuel.
So it's an interesting question because it's actually beyond data protection. You are talking about the rules on the territorial scope of the consumer law, European consumer law, and business law in general. Whether if you are not offering your goods in the EU, not having your website labeled in euros, for instance, etc., then you are not caught, you are not offering services or products in Europe. So the GDPR isn't applicable to you, and you can say that the transfer is occasional. You can rely on this derogation, but it's only if your services are not offered in the EU. And these rules, the the detail of these rules are not going to be in the GDPR. They are going to be in other legal instruments in European law.
Lovely, thank you. I'm going to offer a final word to Neil then before we properly close. Neil, anything you'd like to add?
I was just going to say it's these kind of questions, which is why you have a lawyer on the webinar. So
well, that's great. Thank you. I'm sure we didn't cover everything that everybody was thinking of or would have liked to have been able to ask. But again, I'm going to thank you both. That was a great webinar. Really enjoyed the content. As I say, I've taken loads of notes. You will have seen me looking down. But I think at that point, we can call it a close. So thank you very much. Take care now.
Thank you very much.
Thank you. Bye-bye.
Bye-bye.